Today I've got a story for you, and it's going to deal with two black radio show hosts filed the trademark for White Lives Matter. And I know you're thinking that doesn't make any sense, but hear me out. I'm going to explain to you exactly what happened and what I think is going to happen in the future in today's video. So let's do this. Hey, my name is Jim Hart. I'm back at you here today. Thank you so much. If you're brand new to the channel, I'm excited to share this story with you today. If you've been a subscriber for a while, this is going to be a little bit different than the normal flavor of the videos that I do. So stick with me, but there's definitely something to be learned from listening to this story I've got to you about these two guys, these two radio show hosts who filed actually they didn't file. One of their listeners filed a trademark application for White Lives Matter. And then he called into the show and said, hey, I filed this trademark. I thought that you guys would want to own this because if you guys own it, you can control who's using that trademark. So the name of the radio show hosts is Ramses Ja and Quentin Ward, and they do a radio show called Civic Cipher. And the reason I'm doing this video is because NPR posted an article, I'll include a link down below, talking about how these radio show hosts basically decided to pursue this trademark because they want to control the narrative about White Lives Matter. Obviously, they are big advocates, as am I, of Black Lives Matter, and they wanted to make sure that the other groups out there that are using the term White Lives Matter and selling merchandise with White Lives Matter on it and all these type of things would not be able to actually use that term in commerce. And so anyone who tries to sell a shirt or a hat or anything like that, they claim that now that they own the mark, they're going to send them a cease and desist letter and stop them from doing that. Well, unfortunately, that's not the end of the story, and there are some problems with what it is they're trying to do. Now, first and foremost, the first problem is a trademark, in order for it to be valid, must be used in commerce. So in other words, these two radio show hosts, if they wanted to use the trademark and they wanted to own the trademark White Lives Matter, then they would have to be using that mark in commerce, and it would have to be a way to identify their goods and services that they were selling. So what they did is they filed a 1B application. A 1B application means that they have an intent to use that trademark in commerce. All right, we're on plane number 2. I feel like they come every minute. How is that possible? So they filed an intent to use application, which is totally fine. I do that for a lot of my clients, but at the end of the day, you have to start using that mark in commerce to actually get it to register. Now, that's assuming they get over all the other hurdles that they still have to get over to get the mark to the point where they could actually register it as a trademark they're using in commerce. What also has happened is somebody else has stepped forward, a gentleman by the name of Christopher Carroll, and I don't know anything about this person, but he filed another trademark application for White Lives Matter on November 3rd. And he could have done this for a number of reasons. He could do this because he thinks that these two radio show hosts of Civic Cipher, that they're going to be unsuccessful in their bid to obtain the trademark rights to White Lives Matter. Or he could have done it because he just thought, you know what, I want to start selling some stuff to say White Lives Matter, and so, I don't know much better. I'm just going to go ahead and file the trademark application and waste $350. I'm half jesting, but not really. I think both of these people, Mr. Carroll and the two radio shows hosts, I think both of them are wasting their money, because I think at the end of the day, neither one of them are going to be able to register the mark. Now, I think it's ironic that the radio show hosts are pursuing this trademark, White Lives Matter. I wouldn't imagine they have any intent to sell anything that says White Lives Matter on it, because that'd be counterproductive to everything they're doing to promote Black Lives Matter. And Mr. Carroll might just not have done enough research to realize that I don't believe personally, White Lives Matter can be registered at all. And you might be wondering, well, why is that? Well, I've got a reason for you right here. Neither one of these applicants are going to have issue with prior filed applications, because when I did a search for White Lives Matter, that doesn't look like there were any prior filed White Lives Matter applicants. But they very well may have a problem with the denial that's called a failure to function refusal. And I'm going to read this, and this is directly from an office action that was sent in response to somebody that tried to file Black Lives Matter as their trademark. And it said, terms and phrases that merely convey an informational message are not registrable. The phrase Black Lives Matter is a commonly used message that conveys support for rallies, protests, or movements dedicated to raising awareness of civil rights and protesting police violence and conveying the message of support for the same. Registration is refused because the applied for mark Black Lives Matter merely conveys a message that does not function as a trademark to indicate the source of the applicant's goods and to identify and distinguish them from others. Oftentimes, attorneys will do the research to see if something is trademarkable. So I don't necessarily fault their attorney for not advising them of this, but I believe that White Lives Matter can be looked at very similarly to Black Lives Matter. And because nobody can own the trademark to Black Lives Matter for the reasons that I just mentioned, because it is merely conveying an informational message. It's a social sentiment. It is something it's a message that conveys support for rallies, ending police violence, supporting African Americans, all those type of things. And so I think in the same way, White Lives Matter could be seen as a message that's kind of a radically racist remark. And so I don't believe that. I think what's going to happen is when these guys 6 or 7 or 8 months from now, these two radio show hosts are going to get a denial back from the trademark office that's telling them that White Lives Matter is not capable of registration. That's what I think is going to happen. So what's the lesson to be learned from all this? I think the lesson here is filing a trademark without really thinking through what it means or without sufficient legal counsel is probably not the smartest thing to do. You're going to be wasting a lot of money. And I think in this case, this notion that because these two radio hosts went ahead and filed an application for White Lives Matter does not mean that they actually own the trademark. You don't own the trademark until you go through the entire process, and that typically takes 12 to 16 months. And I think that they're going to run into some unexpected and probably unpleasant hurdles along the way. They're likely going to get a denial from the trademark office for the same reason that Black Lives Matter was disallowed as a trademark. I think that White Lives Matter is also going to be disallowed as a trademark. Besides, even if it wasn't, you can't tell me they're going to come up with a way to sell merchandise that says White Lives Matter. That just doesn't make any sense to me. I think it's a really interesting thing. Sorry, I'm not drinking anything today. I forgot, honestly. So nothing to drink right now. Next time. Take it easy, folks. I'll see you in the next video right here about trademarks. Bye-bye.